Hello guys, welcome back to the news. Atiku Abubakar files fresh motion against President Tinubu at the US court. Yes, my country people, the presidential candidate of the People's Democratic Party, Atiku Abubakar, has filed a fresh motion urging the United States court to overrule President Bola Tinubu's request to stop the Chicago State University from releasing his academic records. Atiku had earlier secured an order from the United States Magistrate for Chicago State University to make Tinubu's academic records available to his legal team. Then the magistrate, Geoffrey Gilbert, had last week ordered Tinubu's alma mater to provide all relevant and non-privileged documents to Atiku's legal team within 2 days. Atiku is currently challenging Tinubu's emergence as the winner of the February 25th presidential election. The matter is currently before the Supreme Court in Nigeria. Yes, so my country people, now there the matter dey. Normally, this matter been there for the Election Petition Tribunal. So as e come dey be like this, so the tribunal now they come talk say, well, with all said and done, now so they discharge Atiku Abubakar's petition. They discharge am both Peter Obi. They talk say all this petition lacked merit because Atiku, according to the appeal court, couldn't provide enough evidence to back up his claims that Tinubu was an alleged drug trafficker and he was engaged in narcotics dealing and had to make a forfeiture of 460,000 US dollars. They said Atiku provided no evidence to those claims he made against Tinubu. And the same goes for Peter Obi, the presidential candidate of the Labour Party. They also discharged Obi's petition. They struck it off, saying Obi's petition does not lack merit. There was no evidence to prove that there was overvoting, and Tinubu wasn't even qualified to contest in the first place, including Kasim Shettima. They filed a petition against Kasim Shettima because of a double nomination. Yes, on the grounds on double nomination. So my country people, according to the Punch, the document sought by the People's Democratic Party candidate through his counsel, Angela Liu, including Tinubu's record of admission and acceptance at the Chicago State University, date of attendance, as well as the degrees, the award, the honors obtained by Tinubu from the Chicago State University. But as the deadline given by the magistrates draws nearer, Tinubu's lawyers approached the US High Court, arguing that the earlier decision by the magistrate needed to be reviewed by a district judge. So the judgment given by the magistrate judge was not enough for Tinubu's lawyers. They argued. So all these arguments and petitions, just because they are trying to delay the process. They don't want these records to be released. So they are not looking for any means possible to halt the release of Tinubu's record to the public. They requested for a review and delay of the magistrate order till Monday, and was eventually granted by the US District Judge. Tinubu's application filed by his New York-based lawyer, Oluwole Afolabi, advanced two reasons. First, is that his academic records in issue are not useful in the Nigerian courts, as claimed by Atiku, because the Nigerian court proceedings and the Nigerian court have explicitly been unreceptive to the discovery. His second reason is that Atiku's request is unduly intrusive because it allows the applicant to conduct a fishing expedition onto the intravenous, private, confidential, and protected educational records. But Atiku, in a fresh response filed on Wednesday in Chicago, Illinois, urged the court to overrule Tinubu's request in its entirety. Atiku's counsel, Angela, appealed that if the court overrules the objections, the applicant respectfully requests that it enters an order requiring production of documents no later than October 2nd, 2023, and the disposition scheduled no later than August 3rd to allow time for transcripts to be finalized and the discovery obtained to be sent to Nigeria, which is 6 hours ahead by October 4th, so that such evidence may in turn be filed with the Supreme Court by October 5th, when the applicant's Nigerian counsel intends to submit any evidence to the Supreme Court. So Tinubu's lawyer explained that contrary to Tinubu's inflated rhetoric, that he is not seeking to conduct a fishing expedition into Tinubu's private and confidential protected educational records. The former Vice President Atiku declared that his goal is to test the authenticity and the origin of the 12 pages of documents, including 2 very different diplomas that purport to have been issued by the same Chicago State University. Atiku maintained that there were discrepancies, between the information and the Chicago State University documents and the information in the affidavits Tinubu submitted to the INEC. So there are so many discrepancies in this information. If the intervenor assessed he graduated from the Chicago State University in 1979 and the Chicago State University documents are authentic copies issued, then there is no reason why he should oppose the limited discovery that Atiku is seeking. And Atiku's legal team argued that the fact that the Nigerian Electoral Act specifically allows for the submission of new evidence to the Supreme Court in exceptional circumstances demonstrates its receptivity to the evidence sought. The former Vice President clarified that he is not seeking the disclosure of Tinubu's educational documents. He is seeking to authenticate documents that are already in the public records, adding that Judge Gilbert's order may only need to be reviewed to clear errors, even if the court determines to the objection should nonetheless be overruled in their entirety. So, why is Tinubu now trying to hide it? So, my country people, the battle continues. This is getting hotter and more interesting. Surely, the truth must be out. Guys, I'm dropping here.